Good morning, and this is in continuation of our last week's lessons. And next week will be the final part of this lesson series. Now, um, our today's topic would be on a few rules, and these are I'm making it simple for you so that, especially those who have not taken up civil procedure or any remedial law classes, will be able to understand right away. So, Rule 8, manner of making allegations in a pleading. So, if you file a civil case, then you will be filing pleadings. So, Section 6 of the amendments to the rules, it says that if you mention a decision or a judgment of a domestic or a foreign court, whether judicial, quasi judicial, tribunal, or a board or officer, you have to attach the authenticated copy of the judgment or decision, because in the previous rules it only mentioned about making the allegations and does not mandate the attachment of the authenticated copy. So the word there is shall, so it must be attached. Now, section 12 of rule 8, affirmative defenses. As affirmative defenses must be pleaded in the answer, so the court must resolve the affirmative defenses within 30 calendar days from the filing of the answer. And affirmative defenses could be res judicata. So you have to include that in your answer, and thus the court is obligated to resolve the affirmative defenses within 30 calendar days. Now, let's continue. Rule 10, amended and supplemental pleadings. If you noticed throughout, if you read the full text of the amendments, it mentions throughout the provisions calendar days. So now you have to be careful, because the rules specifically provides calendar days. So section 2, it's about amendments as a matter of right, and at or in any case of a reply, anytime within 10 calendar days after it is served. So it is a matter of right if there's no responsive pleading yet, meaning the amendment to the pleading, like you will amend a complaint. Now, take note again of the periods. Instead of just 10 days, 5 days, or 15 days, the amendment says calendar days. Now, Rule 13, pleading and service of pleadings and judgments and other papers. So it covers pleadings and motions and other court submissions. Could be manifestations, or like manifestation of change of address. That's possible. Then you have to take note, it's possible that there could be several counsels appearing for a party. So if there's no designation as to who is the lead counsel, then at any one of the counsels appearing. I remember I handled a drugs case, although this is criminal procedure. In open court, the judge asked who is the lead counsel. So since I was the one appearing first before the other lawyer, then I was considered, or the judge suggested that I suggest that it should be Attorney Borracho who should be the lead counsel. So I took the responsibility. So all pleadings were served or were furnished to me, or I mean all orders and resolutions of the court were on notices were served to me. Now, this is going to be the last two slides, so we will just be very quick. Okay, Rule 13 again. There are the amendments provide additional modes of filing and service. Before, the most common would be personal service and registered mail, but now there are two additional modes: by sending an accredited courier. So accredited courier, but it doesn't actually mean private courier because it says accredited couriers. And the date of filing and service is as shown in the receipt. Like there's a tracking number. Also, it can be traced to that. Although the rules specifically provides based on the stamp or the receipt upon the filing or the service. Now, by transmitting through electronic mail or other electronic means if the court so provides, or I mean if the court is equipped, because there are areas in which the internet signal is very low or lagged. So the rule says that only if the court is electronically equipped, and the date of the filing or the service would be the date of transmission. But I'm just wondering, it doesn't say, or maybe I just overlooked that. It doesn't say about read receipt. So it's a feature of mails that you could provide the read receipt. Now, last slide for today's lesson is on the exception to these additional modes of filing and service. It does not apply to initiatory pleadings and initial responsive pleadings like answer, subpoena, protection orders, and writs like writ of mandamus or writ of habeas corpus, appendices and exhibits to motions or other documents, and sealed and confidential documents or records. So you have to take note of the exception. So the additional modes of service and filing does not apply to these four exceptions. So next meeting or next lesson would be, we will be focusing on these four areas of amendments: summons, motions, pre-trial, and trial. And for those who are very interested of litigation, you have to be keen on this. So thank you so much for listening, and don't forget to follow and like our Facebook page, and also share it to your friends or relatives or persons you know who could relate to the study of law or who could be interested. And also, I thank you for all the subscribers of our YouTube channel, and actually it's better to navigate there compared to our Facebook page. And also our website, which is in constant, we are improving it. The team is improving it, and we will be working or focusing on it for your convenience. Thank you so much, and I hope to see you next meeting. And please don't forget to take the quiz tomorrow and our bar guide this Friday. Thank you, and have a happy midweek. Thank you.